The matter before the court is Black Bear Hydro Partners versus the Board of Environmental Protection et al. And we are being streamed live on the web in this case, both by video and audio. This is Kennebec 23491. I think I neglected to say the docket number. If I would ask counsel to identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Thank you. Matt Warner for Black Bear Hydro Partners.
Robert Martin on behalf of Respondent Appellee Board of Environmental Protection.
Bill Kennedy for Respondent Downey Salmon Federation.
2 days in a row. All right. Counsel, if you're ready to proceed, Mr. Warner would be happy to hear from you.
Yeah, thank you. Good morning. May it please the court. I
see you've opted for the green light immediately, so.
Yeah, I always feel like if you all have questions, I'm happy to take them.
All right, let's jump right into it. Let's start with I think a preliminary issue here. This is an ADB appeal from the denial of a permit, correct?
Correct.
And that denial was predicated on 3 independent grounds, and you are challenging one of the 3, which is the Leonard Lake aspect of it. Am I correct so far?
That's correct, Your Honor.
So the fact that the other 2 independent grounds by themselves produce the same outcome, inevitably, which is that there's still a denial of a permit, we can't offer any relief in the setting of this thing, no matter whether we adopt one position or another. That denial is still out there. Is this case justiciable?
Well, this was an issue before the trial court on motions to dismiss, and the trial court did deny the motions to dismiss on those grounds.
But we're not bound by that, are we?
You're, of course, not bound by that, Your Honor. And the rationale there, which could and should still apply, is that this case it would be more efficient. Basically, it boils down to more efficient to decide this question
There's
now.
no exception for more efficient, is there?
Well, it's judicial efficiency and efficiency of the parties and of the administrative process.
Again, that's not one of our recognized exceptions so that we can hear this, is it?
I think we said in the Brunswick case, a case is moot and therefore not justiciable if there are insufficient practical effects flowing from the resolution of litigation to justify the application of judicial resources.
And thank you, Your Honor. And I suppose the practical effects here, aside from simply the efficiency of it, is that if I may take a step back and just explain the posture of the relicensing proceeding, there were 3 grounds denied. One of them relates to Lake Leonard. The other 2 relate to an upstream lake, Graham Lake, and are unrelated to the reasons here. Depending how Lake Leonard is classified, whether it's GPA or B, will could dramatically affect the nature of the relicensing proposal and what Black Bear Hydro Partners would do in order to get this project relicensed and meet state water quality standards. Were this appeal dismissed now without this question being decided, Black Bear would essentially be taking a guess at what should be done.
Well, they wouldn't be taking a guess because the board has already told you what they think.
That's true, but Black Bear, of course, we feel the plain language of the statute dictates otherwise.
So you're contemplating reapplying, correct?
Yeah, the intention is to reapply.
So this is an adjudication. You're not going to win this adjudication because of the other 2 grounds. It's over. Then you say, I'd really like to have an answer about what this statute means. Isn't that what deck actions are for?
Yes, however, in this case,
is anything stopping you from filing? Why did you file an ADB appeal if all you're asking for is an interpretation of the statute so you know whether you have to spend $1 billion in your relicensing?
Well, we did file a deck action along with the ADB appeal.
But it wasn't on this ground.
I would just say, Your Honor, that none of the parties to this case are challenging this appeal.
I get the sense that everybody would like to have this question answered.
Yeah, correct.
The department would like to have it answered, some clarity to move forward. But as I said, we're on an ADB from a denial. But Would you like to jump into the merits of the case?
I would just, thank you very much. I think on one last point, though, is just that, and to be completely frank, I don't know if your honors will decide this weighs for or against my point, but I also think this question of how these two statutes interact has much broader implications than just this river. It affects whether or not Section 467 should be read to specifically require, and what that means. Great ponds to be called out in a certain way affects every impoundment.
I agree. This is a very sweeping, broad issue that affects a lot of things. And you're correct, there is tension in the language there, and you've done a great job of boiling it down to the issue of the word specifically as provided in 465A.
And I think I can boil down our argument to the point that if you need to look at Section 467, you need to look at things like history or geography, or you need to draw inferences, or you think that 467 is ambiguous as to whether or not Lake Leonard should have been included.
So
in this
let
Class
me
B.
back up for 1 minute. Do you concede that if we find the statutory language ambiguous, we would defer to the board's interpretation?
I do, but I don't concede that the outcome in this case is ambiguous.
So you have to, in order to prevail, if you get past the justiciability issue, you'd have to say it's unambiguous.
It is unambiguous that Lake Leonard is not specifically provided as a classification other than GPA in Section 467.
Well, at least in theory, the classification of Leonard Lake is the equivalent of a rulemaking by the department, I think. And that could be challenged independently of a permitting proceeding, could it not?
Well, no, because Section 465A says that all great ponds default to GPA unless this other statute, 467, specifically provides otherwise. So regardless of rulemaking, the legislature has said if it's a great pond, which Lake Leonard is.
But you're saying that Leonard Lake should default to the Class GPA rather than be categorized as a Class B water body.
That's correct, Justice Horton, and that's because nowhere in Section 467 does it specifically provide
But so
otherwise.
aren't you really challenging the department's classification of Leonard Lake as opposed to the denial of your permit in substance?
Yeah, I suppose that's true in practical effect. Though I guess I take issue with the idea that the department...
It's still an interpretation, the department's interpretation of a statute to so classify Leonard Lake as opposed to a rule. But nonetheless, they're interpreting the statute to say that Leonard Lake is Class B and not GPA.
Yeah, the department has taken the opportunity to interpret the statute in this way and decide that Leonard Lake should be Class B, and whether you cage that as something akin to a rule or a administrative opinion, either way, the department doesn't have the authority to act contrary to what the legislature has decided.
In the 4 minutes we have remaining, I'd like to take you right to laser focus to the issue. And correct me if I'm wrong. I believe it's your argument that if we go to Section 467 sub 18, that it basically gives a range, a geographical range of basically the extension of the Union River, that is Class B there. And you point out that in the other sections of, other subsections of 467, sometimes the impoundments are specifically excluded or specifically included, and this one here doesn't include any specifically designated portions of the river, and therefore, because the Leonard Lake is not included, that it should default back to the GPA. Is that correct?
Almost.
Almost.
And I think that the nuance I would put on that is that 22 times we point out in our brief the statute describes a stretch of river that includes an impoundment, and it says including the impoundments. That obviously is a specific provision. Other times the statute does something else. If you read 467 in a vacuum, I think there's no way to dispute that it would be ambiguous. You'd have to resort to things like geography and statutory history, and this court would be bound to defer to the findings of the agency that administers the statute. However, because the phrase specifically provided in section 465A is not ambiguous, specifically provided as a plain
But then
meaning
when you
word.
go to 18 sub A1, it says, from the outlet of Graham Lake to Tidewater. And there's no question that Leonard Lake is between the outlet of Graham Lake and Tidewater, correct?
That's certainly true, but the opening paragraph of section 467 says that this section applies to surface waters, quote, that are not classified as lakes or ponds. So if we were looking at section 467 standing alone, that opening paragraph saying the things we're going to list next are the things that are not lakes and ponds, and this is how they're classified, but we know that Lake Leonard is in fact a pond because of this other statute, that would be ambiguous. But that section 465A solves that problem for us and gets rid of any ambiguity because, again, there has to be a specific provision, and by definition, a specific provision should be apparent from the face of the statute. If you have to resort to things like geography and understanding what the legislature went through to craft the statute, by definition.
But if we go to section 18A, describing this continuum, this uninterrupted line of water, it's as if the statute says, okay, all letters between A and G. And you say, well, they didn't specifically say D, so it isn't really included in that continuum. Is that oversimplifying the issue before the court?
I think if the opening paragraph said this statute classifies every other letter in the alphabet, and then you had all statutes between A and D, because again, this section 465 explicitly, or 467 explicitly eliminates ponds from the things it's classifying, unless it says otherwise. And there's no mention of Lake Leonard or the pond in this stretch of river.
Well, you're essentially arguing that if section 467 is ambiguous as to how a water body is classified, then 465 unambiguously says treat it as GPA.
Yes, that is our
So
argument.
the bottom line is we're supposed to look at legislative intent. Does the legislature ever intend to be ambiguous?
No, but the legislature does intend to say here's a default presumption, and if we don't say
But why
otherwise.
shouldn't we have to identify, clarify, because they were trying to find legislative intent?
I don't think you need to say the legislature intended to be ambiguous. I think you need to say the legislature didn't specifically provide for this thing, and therefore, no matter what you could glean from other factors, you shouldn't even go there because it's unambiguous that it's not specifically provided. Thank you.
Thank you. Mr. Martin.
Good morning, and may it please the court. I'd like to start with the issue of whether or not this court can reach the question of Leonard Lake's classification. We believe the court can proceed with this appeal, and the board welcomes a decision on the merits based on the very unique circumstances here. Namely, where we have a Rule 80C appeal challenging only one of three independent bases for denial of an application, where the trial court denied motions to dismiss raising justiciability concerns and no party has appealed that decision, where appellant has represented that it will be filing a new application for the same stretch of waters, and where there's a purely legal question of what water quality standards will apply in that stretch, and then finally, where all parties agree that the question should be reached now. So based on those unique circumstances, we think the court can reach the merits here. And with respect to the merits, this case starts and ends with the plain language of the statute. Title 38 MRS 467-18 classifies the geographic area of the Union River, quote, from the outlet of Graham Lake to the Tidewater as Class B. Black Bear does not dispute that Leonard Lake falls within those clearly delineated geographic boundaries. Moreover, the word Tidewater unmistakably or precisely describes, as the Superior Court put it, the geographic feature that marks the outer limit of the Class B riverine area. Leonard Lake is impounded by a dam that's located at the Tidewater, and therefore the statute unambiguously classifies Leonard Lake as Class B. And the statutory structure further bolsters this plain language. Looking at classifications on a segment-by-segment basis, as the board did here, is the correct way to read the statute, given the different wording the legislature used within each section to classify stretches of water. In the section at issue here, the legislature defined around bodies of water it wanted to exclude from riverine classifications, such as Graham Lake. However, it does no such thing with respect to Leonard Lake. So for this reason, the court should affirm the board's plain language reading
I
of the
see you're
statute.
green lighted, so why don't we retrace our steps back to the justiciability issue. As you pointed out, this is an appeal from an administrative decision, ADC appeal. A permit was denied upon 3 separate bases. Even if we embrace and adopt everything the appellant is urging here, that denial still stands. We have not produced any practical effect flowing from the disposition of this case. Now, you have an advisory opinion maybe going forward that would help in future matters, but as far as this case goes, it's really moot. There's nothing we can do that will undo that permit.
Well, again, Your Honor, I mean, we moved to dismiss on that basis before the Superior Court, but based on the factors that I've previously mentioned in my opening.
But are those factors that we recognize as factors to say, okay, if these things are present, we're going to issue what is in essence an advisory opinion?
So I think those factors with respect to justiciability really go to this court's prudential considerations and how it looks at whether or not it can hear a case before it. We know that this issue is going to come before the court again. No parties raising the
What's
argument
stopping
here.
them from, we deny the ADC appeal, so it's the adjudication is over. They have to go reapply. It's going to cost them X amount of money if the classification is what you say. Why can't they just file a declaratory judgment action?
They may be able to do that. We don't think this particular case is a declaratory judgment action. I mean, it's clear that the legal issue here is arising from a final agency action,
Well,
which falls
now
under
they're
ADC.
saying, I want an interpretation of the statute. We obviously have a case in controversy. We concede on those other 2 bases, and so now it's going to cost me $1 gazillion. Please interpret the statute for me.
Your Honor, that may be an option for appellants, but again, as we mentioned in our brief, we think the court can reach this issue now.
I'm struggling what the principle is then. You've identified some factors that you said make this unique. It's a Rule 80C appeal challenging one ground. Okay, every Rule 80C appeal. Trial court denied the motion to dismiss. Hate to say this, but sometimes we disagree with the trial court. I think that's part of our role. That it's a legal question. We get a lot of those. And that all parties agree. I'm not sure why that should have any impact. And the only other thing you said is that they're going to file a new application at some point. Well, okay. How does that make it more justiciable, or why any less advisory? I mean, I suppose you can say that that's kind of coming up into the idea of it's an issue that is, going to reoccur, but it's not capable of evading review. It's very reviewable if they file again.
Right. I think all of the issues that we're highlighting really go to the practical nature of the court's ability to consider this now. And again, those are recognized in this court's.
But really, does it come down to anything other than you all want us to do it?
Your Honor, again, we certainly want you to do it. We welcome the court to provide clarity on this legal issue.
Well,
but
there's also an interesting question of, yes, our standing is generally prudential, so we can do what we want, except there's the APA. And if you establish, here's what you have to do under a statute in order to have standing to appeal, then doesn't it become jurisdictional and we have no choice?
That's a great point, Your Honor. With respect to standing and ADC, a party has to be aggrieved by an agency decision. And here, where an entity is challenging a denial of their application, that appears to satisfy that hurdle of showing that they're aggrieved. But there are other justiciability
They're not aggrieved
doctrines.
at the bottom line because they're conceding that they didn't meet 2 of the things they had to meet, so they're conceding essentially that it shouldn't have been granted. So how are they aggrieved?
I think at a base level, Your Honor, it's an ADC challenging the denial of of an application, and that's,
Except
you
it's
know,
not
that's a
really
final
challenging
agency
the
action.
denial. That's the problem. They're really conceding the denial on a couple of the
In the
grounds.
3 minutes you have left, I'd really like to hear you talk about the merits. And in this case, there's tension between these statutes. But the department has designated its own interpretation of them. To what level of deference should we defer to the departments of their interpretation of this particular statute?
Well, as an initial matter, we think the statute is unambiguous. The statutes are unambiguous, Section 465A and
But do you acknowledge some tension
467.
between them? There's a bold statement saying all all great ponds are GPA.
Yeah, I don't know that I'd characterize it as a tension between them. I think you have to look at them together to answer the legal question before the court. And Section 465 says something has to be specifically provided in 467.
But
That
it also
turns us
goes
to
down, not to interrupt, I'm sorry for interrupting. Subsection 1 says, Class GPA is the sole classification of both great ponds of natural lakes and ponds less. So, boom, that's a broad statement right there. And then you go to 467, and it seems to go back to the introductory language that takes it into an exception. I would like to hear the department's rationale and its interpretation.
Sure. So we think that starting with the plain language, whether something's specifically provided in 467, the plain language definition of specifically provided is with precision, or as Black Bear concedes in their brief, by unmistakable reference. We think by defining clear geographic boundaries and using precise language like the tidewater, which isn't used everywhere in the statute, where the
Can I just stop you for 1 second? So I think they even concede that if you just focus on that language is specific. But what do you do with the prefatory language in Section 467 that says all surface waters lying within the boundaries of state in river basins that are not classified as lakes or ponds? And isn't this classified as a lake or pond? And so isn't how is this grabbing into it, the lakes or ponds within the river basin, if it's not specified?
Well, Your Honor, when you look at the statute in its entirety, that is the opening language, but the statute then goes on to classify several things as GPA explicitly, or include or exclude.
And there are many of them that talk specifically about impoundments or lakes within the river basin. This does not.
It doesn't, but it uses a similar mechanism to what's used in other situations where the legislature within that segment is defining around bodies of water it wants to exclude. Here, Graham Lake is a Class GPA water body, and it starts the classification from the outlet of Graham Lake. And it does no such thing, I see my time's up.
Finish your sentence.
It does no such thing with respect to Leonard Lake. So for that reason, we think it's Class B.
Thank you.
Thank you.
Mr. Kennedy?
Good morning, Your Honors. If I may, I'd like to quickly touch on justiciability. There is case law that we've cited and the AG's office has cited that I believe answers some of the questions you've raised. On page 18, footnote 16 of DSF's brief, and footnote 7 on pages 26 to 27 of the AG's brief, this court's prior decisions in Hurricane Island versus Town of Vinyl Haven and Levanta v. City of Waterville very plainly recognize that this court has authority to transform an
We do,
ADB
but
or
in
ADC.
Hurricane Island, for example, the part of the problem was that the administrative appeal did not lie. Isn't that part of the problem? And here, clearly ADC is a mechanism for appealing the denial of the permit. The problem here is different. It's that it was denied on other grounds, and therefore there's not necessarily a live controversy.
Well, Your Honor, I think the focus, and this is also seen in other authority from this court, Annable versus Board of Environmental Protection, which is 507 A2D 592, and Parker v. Department of Inland Fisheries and Wildlife, which is 2024 ME 22. Both of those cases squarely recognize that declaratory judgment action is proper when there is a controversy about the interpretation of a statute.
But not if there's a permitting, not if there's an adjudicative permitting decision
Right.
that we have said is to be reviewed exclusively under Rule 80C if it's from a state agency. That's the problem, is that, and regardless of how we decide the Leonard Lake classification question, I assume your client and the department would be looking for the court to affirm the denial of the permit. And so even if we were to disagree with the department, we'd be affirming the denial. So our analysis would be complete surplusage to the judgment.
Well, I think the law and this court's own decision, I'd respectfully disagree that it limits it so much. I mean, Labonta, the plain language is there that we are not elevating form over substance.
We have certainly said the declaratory judgment is available in certain contexts. For example, anticipatory challenges to involving interpretation of statutes. For rulemaking, if a person aggrieved by a particular administrative agency rule wishes to challenge the validity of the rule apart from any permitting decision, that person should bring a declaratory judgment action. And this strikes me as a rule, as fundamentally a rule of the department interpreting Section 467.
Well, Your Honor, in Annable, and I'd asked the court to look at this, the challenge was to a non-binding advisory opinion. I mean, I think it shows the breadth of the declaratory judgment action.
And I think that's why Justice Connors was asking that question. The problem is this isn't coming to us that way. It is coming to us on appeal of a permit that, frankly, both your client and the department think we should affirm the denial of the permit. That's the problem.
Well, and I think Hurricane Island and Labonta, I mean, it's kind of a two-step
Declaratory
analysis.
judgments actions are, like Justice Horton said, anticipatory. So this case goes away, the permit gets denied, then they file an anticipatory declaratory judgment action saying, we got to do this again, but it's going to cost us $1 billion, so please give us an interpretation. That's a different procedural context. And isn't that what declaratory judgment actions are there for?
Well, frankly, Your Honor, I think, again, there's a concern about elevating form over substance. There's no dispute that this question is going to come back.
It might
We've
be
heard it from
jurisdictional. Do we really have a choice here?
Under Labonta and Hurricane Island, I think this court has plainly recognized that it does have authority to do this. This is a justiciable live controversy. No benefit is served by doing this. There would be a waste of judicial resources. There's ongoing harm to the river, to the people
But
who
it's a
use the
live
rivers.
controversy between the parties, but it's not a live controversy in the context in which it's presented to us, because all we can do is affirm or vacate the denial of the permit, and nobody is suggesting we should do anything other than affirm the denial of the permit.
I would respectfully argue that under 80B, which is Hurricane Island and Labonta, it's the same process where you're either affirming or denying.
This is an 80C. There's a statute, the APA. Doesn't that make it jurisdictional?
I don't think it makes a difference. What we're trying to do is to not elevate form over substance.
You're
What
trying
we're
to get an
do-
advisory opinion for something that's going to happen down the road.
This court's own authority has recognized that on non-binding advisory opinions, it has authority to decide those questions when it's properly before it, which is this case.
Thank you.
Thank you.
Mr. Warner, you reserved 3 minutes, I believe.
Yes, thank you. I think it's possible to find that Black Bear was aggrieved in the sense that that word is used in the APA by this decision, because though the permit will be denied either way, there are concrete costs and consequences that flow to the company.
If
And
we
I
were to
think-
define that as being aggrieved, doesn't that then open up every single ADC appeal as being permissible to seek essentially an advisory?
Well, I think it's distinct in the sense that in this case there is an intent. Black Bear must reapply if it wants to relicense this hydropower project. There's an intent to reapply. This question will certainly be heard again, and
And can
frankly,
be adjudicated in that process very nicely, can't it?
it will, though that process with being adjudicated later instead of now could involve 2 more applications for water quality certification. If Black Bear needs to reapply following this court's decision to dismiss this case, it has this difficult choice whether it decides that the department's wrong and sticks to its original relicensing proposal, goes through this process again, applies to the department, appeals to the board, appeals to Superior Court, ends up back in this court in due course, and then this
Or,
court addresses the
having
question.
remediated the other two things perhaps that the department has identified, you then have a declaratory judgment action saying, we think the department's
That would be our hope.
interpretation is wrong.
That would be our hope. And I would also want to point out that the APA does allow courts to remand with instructions to modify as opposed to rehearing questions, and I think that dovetails nicely with the definition of aggrieved I just offered this court. Okay, thank you.
Thank you. Well, thank you, everybody, for your arguments in this case. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. Thank you.